Implied terms may be implied by fact, first of all. In the Moorcock, the there were ship owners who leased a jetty, a type of pier, to unload their ship. Now, while their ship was moored at this jetty, the tide went out, and the bottom of the ship hit some rocks and was damaged. Now, the contract between the parties, that means the jetty owners and the ship owners, didn't mention anything about responsibility for damage to the ship and so on and so forth. However, the court said that as an implied term, the jetty owners were in fact responsible because this was part of the business efficiency. So this is what's called the business efficiency test, whereby the jetty owners, by allowing the ship to dock at their jetty and be unloaded, they're getting money for that. There's a contract. So by implication, they guarantee that to do so is safe. Similarly, in Southern Foundries and Sure Law, there was a breach of an employment contract, although it was not clear whether it was a breach, because the company at issue had been taken over by another company, and the new company had changed the terms of the company and changed the directorship of the company. Now, this affected Mr. Sherlaw's employment contract. Again, the employment contract itself didn't say anything about this, but the court said that there was an implied term in Mr. Sherlaw's contract that these changes would not happen. And this is what the court called an officious bystander test. So that is, in a way, of course, it's similar to the business efficiency test. These are all tests of reasonableness, but the officious bystander test is more of a reasonable man test. It's about a bystander, someone who stood by while the contract was being formed and interpreted what it might mean, what the parties must have meant. And so in this case, of course, it was implied that the parties must have meant for Mr. Sherlaw's contractual relations, employment relations, not to be affected by these kinds of changes of directorship as what happened later on. Now, in Liverpool City Council and Irwin, this was a relationship between a landlord, the council, and the tenant, Irwin, and there were some problems with things in the common areas. Now, very often these types of agreements, these tenancy agreements, will state very clearly the landlord is responsible for this, this, and this, and then the tenant is responsible for this, this, and this. So the parties agree beforehand what each one of them is responsible for. But in the contract between the City Council and Irwin, the problems were not mentioned in the contract. So the common area that was in disrepair, the things that Irwin wanted to get fixed were not mentioned. So it was not clear who was responsible. And the court said it was an implied term that indeed the landlord was responsible to repair these common areas. Now, in Wong Mi Wan and Quan Kin Travel Services, the problem is actually a very sad case. The problem was that there was a girl who drowned on a package tour. Now, the girl's mother had a contract with the travel agency. The travel agency then had other contracts, subcontracts with people such as the bus driver who took the family to the place where they were going to have their holiday. And then at that place, there were further contracts with other subcontractors such as the a company that supplied a boat to go on a tour and so on and so forth. And it was during one of these boat trips that the girl drowned. And then the question arose whether the travel service company, the travel agency, was responsible for what these subcontractors had done. And the court said that it was an implied term of the contract that indeed the responsibility for third parties rested and vested with the travel agency. Now, apart from being implied by fact, sometimes terms can also be implied by custom. That means they are implied because it is the custom, perhaps the custom in a particular geographic area, or perhaps the custom in a particular profession to do things in a particular way. Now, a very old authority on this is Hutton and Warren. In Hutton and Warren, we had a landlord and a tenant. And in fact, the land at issue was agricultural land, and the tenant had tended to that land and in fact had even planted things on that land. And What happened was that the lease expired and the landlord took over the land again, and the tenant claimed compensation for the seeds they had sown and for keeping the land arable, and the landlord refused to pay. Now, the contract between landlord and tenant didn't mention anything about compensation. However, the courts implied by custom that indeed the tenant was entitled to compensation. Now, the case of Cunliffe Owen and Tether and Greenwood explained what exactly qualifies as a custom that may in turn lead to implied terms. And what it stated was that a custom must be certain, notorious, and reasonable. Now, what happened in Cunliffe Owen and Tether and Greenwood was that a stockbroker had exceeded his authority, and the contract clearly did not allow the stockbroker to do what he had done. However, among stockbrokers, what he had done was the usual practice. So the question arose whether it was an implied term in the contract of the stockbroker, in the employment contract, that he was indeed entitled to do those things because they were common practice, because they were custom in the profession of stockbrokers. And the court said that as long as the custom is certain, notorious, and reasonable, they may lead to implied terms. Now, of course, certain means that people know what the custom is, and it is certain what that custom is. Notorious means it is widely known, so if you ask a stockbroker, they would know about it. And reasonable means that it is not something that's, for instance, illegal or some practice that is unreasonable. So we go through these three tests, and if we can show that the custom satisfies those tests, then very likely we have a case of an implied term. Now, lastly on this issue, we can look at the case of Les Affréteurs Réunis and Leopold Wolford. This is a case where Leopold Wolford helped with the formation of a contract between ship owners and charterers. In other words, Leopold Wolford was the broker. And Leopold Wolford was supposed to be paid his commission, but he wasn't paid his commission, and a problem of privity came up because he wasn't able to sue on the original contract because that was between the ship owners and the charterers. This was overcome by saying, or by the court accepting, that in fact a trust had been formed of which Leopold Wolford was the beneficiary. What this case also shows us that if there is an express term in a contract and that express term contradicts a custom, then you cannot imply the customary term. You can't do that. So in other words, parties can overcome the implied terms by custom if they don't want to be bound by any implied terms by custom by expressly agreeing different terms. Now, lastly, terms may also be implied by statute. Now, the big example of this are sales of goods acts. So where someone goes, especially a consumer, goes and buys something, they are entitled to certain minimum warranty periods. And of course, there's sales of goods act throughout the world, and the terms of those acts will vary from country to country. But the idea is that whatever the parties agree, so whatever in a sales of goods scenario, whatever the buyer and seller agree, the Sales of Goods Act can come in to the situation and basically usurp whatever the parties agreed. So if the parties agreed that there would be, the seller would not provide any warranty for the goods being sold, then indeed the Sale of Goods Act can be used to say, no, there is a warranty of, say, 6 months, 1 year, whatever the case may be. So the statute, in effect, trumps the terms of the contract. But it really depends on the particular statute whether or not that is indeed the case. So overall, we hold that sometimes terms can be implied into contracts by the courts, and this can happen because of facts, it can happen because of customs, or it can happen because of statutes. Let us briefly summarize. Generally, contractual terms are those terms upon which a party can sue. If something is not a contractual term, then it's probably just a representation, a mere representation. And usually a party cannot sue upon such a representation. Now, if something is a contractual term, it can be either express or implied. Express terms are those that parties expressed and intended to be bound by. Implied terms are those that are implied into a contract, usually by the courts, and they can be implied by fact, custom, or statute. Thank you very much for your interest.